Okay. Welcome everybody to the latest meeting of the Member Advisory Group. As you know, it's a meeting held in public and is being streamed live through the cameras. We'll move to the first part of the agenda, which is apologies for any absence. None. Which I say is none. Thank you. Any declarations of interest? That's a none again. Thank you very much. We'll move on to the minutes of the meeting held on 21st of November 2018. We've all had a copy of that. We have a comment.
Question in respect to the minutes. When you come to them, are you taking questions?
I'll take your question now. Were you there, please, Councillor Nelson?
Thank you. There are one or two points to clarify in respect to the minutes. I note at the bottom of the first page, which is topped A in the top right-hand corner, the final paragraph there, it makes reference to two survivors and a member of the Survivors Committee. I'm just noting it says Survivors Committee there, which it does. And indeed, at the top of the following page it says Survivors Committee. I've got a question about at the second paragraph. I think we might as well make sure that the minutes are absolutely correct, as we all remember.
When we talk about minutes, we go to the accuracy of the minutes. That's all we talk about.
Which will depend on also what we all recall as being the conduct of the meeting. Yeah.
I'm moving, Chair.
I think probably that we need, from the purposes of transparency, to make absolutely sure we do have in public clarity about what the minutes are recording, because the inquiry will be current instances of CSE and the historical record, and this process will form part of that historical record, so it needs to be right. So I think you're precipitate.
Can I ask you to make the point that you're going to make, please?
There are two things. Under CSC IMAG 15, it refers to current position. I think that should be current instances. I would ask whether the Survivors Committee representative is happy with the précis of her remarks that she made, and I'd like to clarify, please, that while it says Survivors Committee, in the minutes of those present, it refers to the reference panel. Are they the same body?
Well, yes, they are, I believe. Is that correct? Yes, they are.
And the
yes,
Chairman, they are the same.
Well, body. No. Let's for the sake of absolute clarity, the reference panel was the thing that was originally initiated. When that panel was continued, they then determined to rename themselves and call themselves the Survivors
Absolutely
Committee.
Right. It was page
so
20.
That's their right.
You're right. It was the page 20 and page 27. Sorry, of the previous minutes to the meeting of the 20th of June. Bottom paragraph. It says the council agreed to request from the Survivors Committee to be renamed the reference panel by the survivors. So yes, I knew that. Thank you. The reason is that in respect of all of the records of this inquiry, and not just these minutes, the lead cabinet member on the 22nd of October wrote to me and other members of the advisory body to say that he would provide a copy of the statement of the Survivors Committee. I just want to be absolutely clear who the Survivors Committee were. And at that point, on the 22nd of October, there were only two members of the Survivors Committee, and they're named individual in these minutes. So I would ask, please, for the completeness of this process, if I could have a copy, as promised, of the Survivors' statement, which was read out at the...
That's not going to the accuracy of the minutes, so we can deal with that outside the meeting. I'm sure that can be provided.
I want it recorded in this meeting, in public, with people listening.
And I think that can be recorded in the minutes, but the 3 points you brought up, we'll just quickly move on to those. One of them was whether the member of the committee felt that her remarks were correct. Can I ask if there's any issue with that, please?
I did bring it up in the last meeting regarding the delay in the process, and I thought that was it, and I made it quite clear. Yeah. There's obviously still some confusion.
Well, the element that I was curious about, where it says that she felt the survivors was blamed solely in the media, and they weren't blamed solely in the media, they're also blamed by members of this council for delay.
Right.
For instance, but that was just an observation on my part.
Can I ask you if you're happy with the way the minutes are as they stand?
Yeah.
I'm happy.
That's fine.
In the way that the minutes are.
Good.
Fine.
It was pointed out
Yeah.
But if there's still
No, not at all.
confusion,
It's whether
or,
you're happy with, if you're happy with that, how that's worded, then fine, absolutely. Fine.
When it was taken back to the Survivors Committee, the survivors themselves said that they were happy with the process that it had taken because they'd been fully involved in the process.
Okay, so we're really looking at the accuracy of the minutes now, and that's where I want to stick with this, if we may, please.
I want your assurance that I will receive a copy of the survivor's statement with the date at the top and the names at the bottom.
Is that possible?
As promised
This
in
is
this
not
email.
we're talking about the acceptance and the accuracy of these
Yes.
minutes. That is not an issue for the acceptance and accuracy of these minutes.
I'm sure if you have a word with the monitoring officer afterwards,
Absolutely
something can be
not.
done
It
with
wants
that.
to be conducted and clarified and agreed in public, please. Not outside this. The point about this is transparency of the process. It's why we're having this inquiry, because we don't do things outside the meeting. We don't have conversations
But
in the corridor
this
afterwards.
agenda item is about the accuracy of the
exactly.
minutes. That's what this agenda item is about.
Will you agree then that we introduce an agenda item where this is covered off in this meeting?
We can make sure that it comes onto the next agenda for the next meeting, but we don't add items to agendas either in those circumstances.
Are you saying you are not assuring me that I will receive that survivor's statement?
You're
No one-
putting words into my mouth, Councillor. I'm not going to give you
No one
that
is
choice. We
saying
just
that,
need to
Councillor
deal with
Nelson.
the
We are
business.
trying to just look at the accuracy of these minutes. And we have a
Chairman,
move
it has been moved
and it's been moved and
I say
seconded.
We move on. If
Is
you're
everyone
happy with
happy with
everything.
the accuracy of the minutes? Please show.
Wrong.
All those in favour? All those against?
They don't vote.
Right.
can't
So,
vote.
so all those in favour, there are 3 of us. All those four. Those against? Councillor Bentley.
I'm not committing myself on that one.
So is that an abstention?
It is.
Right. Thank you. So we have got to the point where we can sign the minutes, which I will do at this stage. Thank you very much. Right, moving to the next part, which, as we know, is a report from the commissioning body on the final commission, and it has been split into 2 parts. Jonathan, would you just like to say a few words on that, please?
Thank you, Chair. So, I'm pleased to report that the commissioning body has been appointed. They've been in post for 15 working days now, and have been working to make the inquiry happen. Their duty is to produce a final commission, and that's constituted of 3 elements. One is to appoint a chairman, one is to finalise terms of reference, and one is to support the organisation of the inquiry. The report before you today is effectively the handover of this process to the commissioning body, and their report on the delivery of the first part of that final commission, which is the recruitment pack for the independent chair. In respect of the decisions for you tonight, there are 3 things to either comment on or note. The first is the recruitment pack for the independent chair. That documentation was circulated earlier this week. The comments that the advisory group make tonight will be considered by Cabinet on Thursday in their deliberations about whether or not to sign that off. The second is to note the report from the commissioning body about how they will then deliver the second part of the final commission, that being finalising the terms of reference and the organisation of the committee of the inquiry. Really just following on from that, note the progress that they've made since they started working on this. Chair, obviously there are questions. I don't know whether or not it's a good time to introduce the representatives from the commissioning body.
Yes, if you will.
And invite them to go through the pack.
Yes, so if you would like to take the floor, please.
Okay, well, hopefully everybody's had chance to consider the recruitment pack, which contains a draft advertisement, the full applicant pack, an application form and a number of appendices. Obviously, we are keen to hear any comments or take any questions.
Okay, and that said, we'll open it to the floor. Councillor Nelson, have you any questions on Part A of the final commission, please?
We're looking at Appendix A, recruitment pack. Is that what we're considering?
Yes, we're looking at the
Appendix
recruitment
A.
pack for the position of the independent chair as
Okay.
proposed by the commissioning body.
If we could go that. So page 2, draft advertisement, fine. And then the purpose of the inquiry is to fully investigate and establish the facts. Fine, because that covers current and historical. And then we've written, and this is the role description, though, so this is what the independent chair is expecting to be inquire. And it says to identify if and where public and other services have failed, and that's historical, that's in the past tense, and that needs to be including or are failing. You need to include the present tense in potential failures, not just historical. Okay, halfway down, engage with all relevant stakeholders, applying a strategy that recognises the inquiry's limited powers to compel. I noticed that disclaimer is in a number of times. Is that something you have to put in?
So because this is not a statutory public
Understand.
inquiry, we
Yeah.
don't have powers to
Okay.
compel documentation. So that is about transparency
Sure.
and making it clear to
I'll
everybody.
just remind the members of the committee here and the public listening that that disclaimer is in a number of times in this document, so I will only raise it once now. Thank you. I've got a question in respect of, you'll forgive me, this point's on probably most pages, so we'll
Okay.
just go through it. Page 4, item 315, and this is a piece of my understanding. What it's saying is the independent chair is being contracted, and we'll come to who by, it's being contracted to deliver against the terms of reference. That makes sense, otherwise how do they know whether they've succeeded or not? But what it says is that they're required to be subject to meeting all elements of the terms of reference. Now they could be reporting a draft report a year or a year and a half from when they originally established the terms of reference. Is that subject to mitigation that if 99.9% of the terms of reference are met, the report can be made? Or could there be a blocking terms of reference, which means the report never sees the light of day? How does it work?
So a chair could still report on the fact that they haven't been able to meet one of the terms of reference and what the reasons for that are. So that in itself wouldn't stop the chair reporting.
I ask you then to change the wording so it changes from subject to meeting, because subject to meeting in a court of law would be it has to meet all of them. Thank you. I note the delay between November 2018 and January the 22nd, 2019 of establishing the contract with Eversheds. Okay. Over the page, item 4, the purpose of the inquiry, to fully investigate the facts of, and that covers current and historical, and again, as I've said, please, if we could include have failed and are or failing. Thank you. Role purpose, halfway through, the independent chair shall ensure the inquiry gives the public confidence that the issues relating to child exploitation, not sure that wording is fortunate in terms of issues, I'm sure issues frankly covers it. Very pleased to see over the page 6, experience, you're looking for someone who may have experience or in stopping child sexual exploitation and bringing perpetrators to justice. Good. I wonder if in your enumeration, page 7, you could explain to me why, and this appears a number of times in the report before us regarding the recruitment pack, that the point is made that the applicants are reminded that it will be the council, a local authority, who will bear the cost. How is this relevant? I understand the council has budgeted a more than ample sum to cover off this inquiry, and that cost won't be an issue?
I don't think that's about saying that cost is an issue. I think it's simply about reminding applicants who may work currently in the private sector that this is actually something that's being paid for by public funds. I don't think that in any way curtails
Except
the
that the
remuneration.
value for money is one of the criteria when you're comparing one candidate against another.
It's only one of a number of criteria.
Okay, but I would make that point that we're aware of that. Yeah.
Okay.
We don't want the cheapest just because it's a council.
No.
And sell people short. Good, thank you. In terms of appointment, thank you for everyone's patience, by the way. It will take a little while. It took a little while to read. In terms of appointment, it says that the successful applicant will take up their appointment as soon as possible. but over the page, at the top of page 9, it says, bearing in mind the above timescales, all applicants should be aware they are available to begin work, if appointed, from May 2019. So, which is it? Because one is saying, quite rightly, you want someone to start when you work back from our process of you establishing your recruitment media, you go to market, you give a month for someone to come back. You've got a recruitment process where you have first, second, third interviews, assessment centres, I don't know, whatever you're going to have to recruit your person. Then they've got to give their own notice, potentially. So you get to May, and that date's quite significant in the calendar of Telford Wrekin Council this year. So it's not a surprise it's May. There's an election in May. I just wonder why there's that contradiction between as soon as possible, but you've actually got a date that follows.
Well, because until we start the process, we don't know quite where that timetable will end up. So to give you an example of that, if we are going to advertise in certain publications, how quickly we can get that advert in depends on the cut-off date for those going to press. So we might be able to advertise and get it in next week. It might take a month, depending on the cut-off date. So all we are trying to do is be clear with the applicants that as soon as we can complete this process, we want to be able to do so. And we want them to be ready to then be engaged in the process at that point in time. So we are trying to retain a degree of flexibility to allow us to do this quicker if we possibly can.
And equally, we're aware that since we're now in February 19, and this is not Evershed's fault, but we asked for an immediate inquiry in April 18, that is not
Can we stick to the point, Councillor Nelson, please? You're making points here, but you're really...
Are you suggesting that I'm not raising things that aren't of interest and importance to the public in this process?
No, I'm not. I'm suggesting to you there are other people that may wish to ask questions.
I'll be as concise as I can going forward.
Thank you.
I've already raised page 17, remuneration. I've raised that point about value for money. I was interested to read the bodies who would constitute a conflict of interest declaration, which is pretty much everyone, to be honest. So, but that's only to be debated whether it would be a constraint or not in terms of the nature of the conflict of interest. Now, there is a slightly more difficult element I found, and something I frankly not understood properly, and I'm frustrated that I didn't understand this properly. When we get to page 21, we have details of the contract of employment. I want to make it absolutely clear to the people around the table and the people listening that the contract of employment between the independent chair, and whoever employs them, will be between Telford and Wrekin Council and the independent chair. Telford and Wrekin Council will be the contract.
Sorry.
That's what it says.
So Appendix 4 isn't a contract of employment. This is a data sharing agreement between the council and the chair, because there will be data shared between those two bodies. So the contract with the chair will be with the commissioning body.
That's not what it says.
This is a data sharing agreement. It's not a contract.
Mm-hmm. I'm confused. If we go to page 26, whistleblowing, the authority is committed to the inquiry being undertaken to a high standard and with the utmost competence by the independent chair. If the commissioning body or any third party attempts to influence the independent chair, it's to be raised with the authority, and that's Telford and Wrekin Council's whistleblowing officer. And the third party in that instance could be Telford and Wrekin Council, who are trying to influence the inquiry. And an independent chair would need to raise that with the council's own whistleblower. Is that correct? It's what it says.
So just to clarify, so this is a draft data sharing agreement, and it is a draft data sharing agreement.
Right.
So it is something that has been put forward to us by the council. It is by no means the final version. That's why it is in draft at the moment.
Okay. Well, because we've got points like point 12 termination, 12.1b, the independent chair willfully damages the authority's reputation, as defined by whom, for instance, and in the context of determination, the contract, which says at the beginning between Telford and Wrekin Council and the independent chair, says that the contract can be terminated by Telford and Wrekin Council under these conditions. Have I misunderstood? This is not the contract of employment between Eversheds, under which the person is going to be employed.
No, this isn't the contract of employment.
Could we make that clear, please?
Okay.
The reason is that there's no termination grounds for the individual, only for the Telford and Wrekin Council.
Can I ask some questions in respect of that?
Please.
This is about the council that it is reasonable to foresee that there's going to be a transfer of sensitive data, personal data and things that could be travelling between the council and either the commissioning body and the independent chair.
Mm.
We have a similar arrangement with the commissioning body in respect of managing, under data protection rules and legislation, the protection of that. We've got a duty to protect that information. So this is about making sure that with any party who we give information to, that there are obligations that they owe to us directly in respect of the management and the protection of that information. So this is a data protection issue rather than in respect of particularly the contract of employment. So if, for example, a chair was willfully breaching data protection rules, frankly, I don't think the council might take the council might take a view about whether or not that's an appropriate person to do that. So this is about setting out that relationship in respect of data.
Okay. Oh, thank you for that clarification. To that end, though, because it is pretty one-sided for those who read it, just as a final observation, then, in respect of this agreement specific to data sharing, point 9.2, which is on page 28. Except as expressly stated in this agreement, I can't find elsewhere where it doesn't expressly state, the authority makes no express or implied warranty or representation concerning the confidential information, including its accuracy. Now that's effectively a disclaimer on the part of the council that the information that they provide the independent chair may not be accurate. And if it's not accurate, there's no recourse, because that's what this says.
I think if I may, Chair, the point there is there will be files, the information, it's evidence rather than accurate information. So if there are file notes, we're never going to warrant that those file notes are accurate. Those file notes are what those file notes are. I'm not saying they're not going to be accurate, but it's about the transfer of evidence.
Okay. The sort of thing I'd be cautious about would be saying it's an accuracy or completeness. If half a file was sent but the other half did exist, there's no recourse, because this says there isn't. I'm just making that point so we're all understanding just what the caveats are that have been put into this process, which I'm not, frankly,
I think if I can be clear on that, I think that's a really important point. This is about the protection of the data. There are other, the council has complied and has said it will comply fully with the requests of the information of the independent chair, and therefore there wouldn't be no suggestion that the council is going to be picking and choosing what is sent. That's the commitment has been made by the council that it will fully comply with the request from the independent chair.
But if it does, there's no recourse because the contract says it's okay.
Well, like I say, I think that's a different point.
Okay, we've had a number of comments from Councillor Nelson. Does anyone else wish to make comments on the recruitment pact, please?
I'm coming back onto that for a minute. In the event of a termination, what would happen in respect of any evidence that was collated by that chair, and should that be evidence be able to be represented from the to an appointment of another chair?
Good point, Steve. At the moment in here it says it has to be destroyed or given back.
Councillor Bentley is asking the question. Can anyone answer that one? I'm afraid I do not know how to answer that.
I think what we've got here is a fairly standard document in respect of the management of information across in responsibly under data protection legislation. You're moving into situations where there are significant breakdowns in relationship with the chairman, which so the management of that, this wouldn't mean that the inquiry would terminate or or would stop, or the information would be destroyed, we would make provisions in respect of either securing that information. What this is about is making sure that information, and this is, you know, we're potentially talking about massively sensitive information.
I understand that.
The fundamental principle, one of the most important principles of this, is that we make sure that that information is always protected.
But in the event that any of that material were disclosed, legally, it would not be admissible in court. Am I right or am I wrong? If it becomes out into the public domain and you're looking to prosecute later on.
Well, that's, again, that's, if I may, Chair, you're confusing. This is an inquiry that the council is running. And this is what we're concentrating in respect
individuals
of that.
may or may not wish to take action.
But that's a separate matter, and that information will have to be dealt with at that point, depending on the circumstances at that time. What you've got at the moment is this is concentrating on the management of the information for the purposes for which it has been provided, which is this inquiry.
Okay. Well, that's the answer. Thank you for that, Jonathan. Any other comments on the recruitment pack, Nathan?
Is this process along the same lines as the Shipman and the Jersey inquiries you presented, the application packs?
When you mean process, you mean the recruitment of the chair. So on those inquiries, the chairs were in post before Eversheds were in post. There wasn't a commissioning body. They were structured in a different way because they're statutory public inquiries.
Okay, right, thank you.
Okay.
And I'd just like to really hear what the Survivors Committee think about this.
To be fair, Eversheds had come along and spoke to us about 3 weeks ago now and talked to us about the process, talked about the timescales so that the survivors were prepared and what did they think and to get their views. And we left following that meeting with Eversheds with the survivors feeling it's at that final hurdle now, I think we're right in saying, that that we feel that we've been listened to. You've gone to the bidders' day, the process has been there, it's been transparent as far as we've been concerned because we've been able to get views from the survivors to put their points of view across. I think by having a independent solicitor in place, which we still have at the moment for reflection and to see the process forward to how it's going to be dealt with, I'm speaking on behalf of the survivors.
Thank you.
Okay, thank you. I'd like them comments for Cabinet as part of our recommendations, and I'd move the recommendations, to be honest.
And I would second that, as long as you're happy, on which you say you are. So I would certainly second that.
Okay, well, we have the recommendations moved and seconded.
With all due respect, Chair, I don't believe we've covered enough in this document to be moving it that quick. We're not here tonight to expedite this in any way, shape or form. We're here tonight to make sure this goes through properly.
And we're also here to stick to the point, Councillor Bentley. So if you have some questions,
there are points in here that need to be clarified.
Well, make the points.
Certainly. Part and parcel of this, within this report, unless I've misread it, it says who is responsible for producing the final report. What I've read, it indicates it's a commissioning body. Surely, in my opinion, the author, that's the independent chair, should be responsible for bringing forward this independent report.
Oh, yes.
So
You cannot class it as independent if you are actually going to censor it.
That question, if we may, please.
Okay. So the chair will be responsible for producing the report. It is the role of the commissioning body to ensure that that work moves forward and it moves forward at a suitable pace and that we get to the point where we have a report and that report is based on the evidence that has been put forward. So it will be the report of the independent chair. It is our role to facilitate that.
And then another point I'd like to bring up is within parameters, because during the inquiry those parameters almost certainly are going to expand. How are you going to account or allow for that? Or are you going to be restrictive to the parameters you have set?
So when you say parameters, do you mean the terms of reference of the inquiry?
It says parameters with all due respect.
Yeah, so The inquiry needs to work to terms of reference so that everybody is clear what it is the inquiry is achieving or is seeking to achieve. Of course, it's the case that as the work of the inquiry progresses, things may change, because as a commissioning body at the moment we have no documentation, we haven't spoken to any agencies, we haven't spoken to any witnesses. And that's why there needs to be a consultation process around the terms of reference, which there will be. And when we start the work of the inquiry, we will have those terms of reference, so they're very public. Might it be that as the work of the inquiry progresses, changes need to be made to those terms of reference? Very possibly, but we won't know that until we start the work.
Can we then ensure that within the document it says that particular word, we include the word not restrictive?
Okay.
And then I would like to touch on page 27. 8 of the document, and it refers to two words which I find uncomfortable. At A and one at B. At A it's destroy, and B it's erase. And I would like this, if it can be accommodated, put in there. At the conclusion of the inquiry, all evidence, responses and information pertaining to the inquiry shall become the ownership of the authority and securely retained for a period not exceeding 10 years, thereby protecting any statutory rights of individuals or organisations that may wish to challenge outcomes or findings under legal process. On expiry of this stipulated period, any destruction of material gathered and recorded for this inquiry would be destroyed by the relevant person responsible within the authority, in conjunction with any duly recognised leaders from the political bodies that make up the combined membership of the council and duly witnessed in writing. This, I believe, does provide both transparency and accountability.
How do you feel about that?
So just to point out that this is the contract with the chair, so this is about the retention of information by the chair, which isn't the retention by the commissioning body. So in our own agreement that we have signed with the council, we've already got restrictions in place in terms of us holding on to the data for a period of years. So this is about solely the chair and the data that they would hold on their laptops or their hard copies, and that's about making sure that there isn't kind of data just out there, that actually the retention of it is done in a very organised and structured way.
Which I would assume is a standard practice within this kind of inquiry.
Yes,
Yeah.
so we have got, we as the commissioning body have agreed to, I think it's 6 years for the retention of all data, which is quite standard for us to hold on to material on behalf of inquiries, as we're independent in that way.
So the council would become the owners?
So we will still keep a copy of that information for that period of time, even if the chair hasn't got that information.
And that protects the legal process and the statutory rights of any individuals or organisations, does it? Should they wish to challenge legally?
Well, it means that that information, should there be a challenge to the work of the inquiry, we have still got a copy of that information.
Okay, any further questions from anyone?
Before we go to
Proposal in a second.
proposal second, I would like to confirm what comment you're taking forward of mine in respect of item 5 whistleblowing. Because whether I vote for it or not, the comments are going to go forward. I just want to make sure that I understand what you're going to take forward, if anything.
I think the explanation of why that's there is in respect of whistleblowing, in respect of data breaches. So I would say you need to have that in there. That would be the advice to the committee. But actually this is about, and I'll stress again, this is about managing the data that's there, which is absolutely principal to it.
But section 5.2 doesn't refer to data. Perhaps it should do, but it doesn't refer to data. The wording is very clear. If the commissioning body or any third party attempts to influence the independent chair in such a way that he or she reasonably has a concern that the inquiry's competence, integrity or independence may be threatened, They are strongly encouraged to raise such issues with the authority's whistleblower. It doesn't talk about data. It does talk about influencing independent chair, which would compromise the inquiry.
The only other thing I can add to that, of course, is that the nature and the extent of the contractual relationship we have with the chair should be as limited as it can be. There is what this again is positioning is talking about where the independent chair comes under undue influence from other people other than the council, including the commissioning body. So the commissioning body can't be the whistleblowing process.
No.
There are
Any
you
third
would
party
expect
includes
the
council.
circumstance.
That needs to be an outsider.
You would expect the circumstances that should the council in any situation be wanting to put or be seen to be applying undue pressure, the chair would be talking to the commissioning body, and that would come through that way. So we're just managing as many options as we can by making provisions such as this in the contract.
I'd like you to record that I'm not happy with it at all.
Noted. Thank you. We have a
Record.
yeah, it's been moved and seconded. All those in favour of all three recommendations, raise your hands, please. All those against? It's passed. Thank you. And that, I believe, concludes the business of the meeting. Thank you.